What I would much prefer to do is be guided by what you want to find out about. I brought with me a couple of examples of things that might provide some information for you. I'm sure you get questions about about registration of computer programs and databases, and perhaps also microcircuit chips and their masks. And that I don't know, but I rather doubt if any of you have ever seen any of these things. So I brought some examples of them along for you to show you and try to explain to you a little bit about what they are, which I think might be as worthwhile a thing as any. Now, if you have any particular questions or things you would like me to discuss, let me know.
Yeah.
Do you want us to just start? Or?
Yeah.
Why did the office decide in '64 to start registering the computer programs? What prompted them to investigate that, do you know?
Okay. Let me sort of take an inventory of questions. That's one thing you want to know. Why?
Right, what prompted them in '64?
Okay. Are there any other particular
Yeah.
things that I should cover?
What about the arguments about the discs being analogous to sound recordings, bearing the same relationship to sound recordings and music?
Okay.
Well, what's your normal line when you say Section 117 says whatever the law was as it was on December 31st, 1977, what is that law? What is the scope of protection?
Okay.
In that same vein, how does copyright law, which we know a little bit about, connect with the patent law relating to
Okay.
programs, if at all?
So far we have standard speech number 3.
That's right.
No, your speech isn't complete without telling us in our language what Contu has recommended to be.
Yeah.
Okay.
The other thing is, if you elect to register a computer program that you are also seeking trade secret protection for, and you don't ask for special relief because of the proprietary nature of that material, have you forfeited trade secret protection? And I noticed that John, in his speech to the Federal Bar Association, said that if you do ask for special relief, he's worried about the nature of the record that we end up keeping, the archival record that we're keeping. And he even mentioned something about going back to Congress and getting some kind of special legislation. Anything about that?
Okay.
Yeah, in the same vein, what
I should be taking notes.
fundamentally with the examining question, I'm fascinated by your pile of cards there. To what degree do we know what we're registering? And if people send in the identifying material, the first and last 25 units, and we don't have a permanent copy of everything we register, of what value is that registration?
And lastly, the Edwards bill, and where it is, and what about the fact that 2 of the major companies failed to support it?
Okay.
When looking at that, when Mary Beth raised 117, what's the relationship with that with the preemption section? And I thought at one time Senator Ribicoff was doing work on establishing a separate mechanism in the federal criminal statute for protecting theft of computer programs. Do you know anything about that?
Well, I can answer that one very briefly and very quickly. And that is, there is, to my knowledge, still active consideration of the Ribicoff Computer Crime Bill, which would establish criminal sanctions for misappropriation of computer time services and information. But that's totally a criminal statute. There are no civil liability provisions involved in it. It grants no private rights, as would copyright. And as far as I know, it's still under some low level of consideration. Some states in their legislatures have passed very similar bills. California has one pending right now, I understand.
It's called the Ribicoff Computer Crime.
Ribicoff Computer Crime Bill, I don't recall its number right offhand in the current Congress. Are we underway now, Elena? Are we?
Oh, yeah, she's
Okay.
been taping it all.
Okay. Well, I think I have some idea of what you'd like to hear. And let me sort of start at the beginning then. Computer software or programs, and the term that, when I use the term computer software, I tend to mean only computer programs, not computer databases, but a lot of people lump both things together under the term software. In computer parlance, in computerese, the term software has a different meaning than it does when you're talking about media people who talk about software, meaning things like television programs or audiovisual materials or educational materials. In computer parlance, the typical computer person, when speaking of software, means a computer program. And the reason they call it that is because it's software, it's something that can be easily changed, as opposed to computer hardware, the physical parts of the machine, which aren't so easily changed. And that's the great virtue of the computer. It provides a way to, in a sense, organize a whole bunch of special purpose machines to do a lot of different tasks which might otherwise have to be done by human beings with a great deal of mental drudgery involved. And the early computers were controlled by plug boards. Big boards about 18 inches to 2 feet square that had a whole bunch of wires with little plugs on either end that you plugged into these boards to actually change the physical circuitry in the inside of the computer to make it do different things. And those plug boards were also called program boards because that's what they were. They established a program for the computer. But it was a program that had to be very laboriously set up on these plug boards by a technician with wires going from point to point to point. And while it gave a good deal of flexibility to these machines, certainly it's a lot easier than unsoldering wires and resoldering wires or changing vacuum tubes or whatever you might have to do to change the circuitry, it still wasn't as easy as people thought it might be. The next step after the development of plug boards to aid in controlling computers was the development of devices that would enable computers to accept instructions printed on something like these punch cards and in effect do their own replug board wiring inside, but to do it electronically and not to do it by actually changing plugs. And the early languages that these things were written in sort of corresponded to the set of coordinates that would be involved in these plug boards. They were just strings of numbers. And they, like the plug boards, were very, very laborious to construct, tedious and time-consuming. It involved someone sitting down and figuring out that you had to connect memory location 000234 with memory location 074865. And writing all this information down as to what should be connected in what fashion. Well, people decided that that wasn't really a very efficient use of human beings and that there should be some better way to go about instructing the machines. So the next step was to develop mnemonic languages, mnemonic codes that corresponded to some of the most common connections that were made. Something like to load a register, which is a part of the computer where computation is done with the contents of some named storage location. And they might typically be things like LRA followed by a number. It means load register A with the contents of memory location such and such. And dozens of other instructions to cause the computer to do other things. That was a lot easier than writing out the strings of ones and zeros or octal-based 8 numbers that were needed to instruct the computer, but it still wasn't as efficient as people thought it might be. They wanted to be able to communicate with the computer, in a sense, in a language that was much more like the language of business or the language of science with which most people in the computer world dealt readily. So there were developed some programming languages. The principal ones that were developed early on were called Fortran and COBOL. Fortran stands for Formula Translation, and COBOL stands for Common Business-Oriented Language. The language of Fortran looks something like algebraic notation. It has things in it like parenthesis A plus B equals C. You can write things in sort of standard mathematical notation. It was developed to aid scientists in writing. And the task of translating these things that people are comfortable with to the kinds of numerical information that the computer needs to organize itself was turned over to the computer itself. And the computer is able to translate from these somewhat human-like languages into the internal information that it needs to organize itself, totally automatically without human intervention, using other programs that are written for this special purpose. Those are called compilers or assemblers or translators. The other language, COBOL, which is the kind of program that I have with me today that I'll pass around to let you look at, is written for business processing, and it has things in it like read and write, and it looks somewhat more like English than does a Fortran program. I hope I brought the program. Yeah. No, I didn't. I think all I brought was the output from the program. No, here's the program. The programs in the early days of the computers tended to be written for one computer and one computer only. The early computers were generally one-of-a-kind machines that were built for a special purpose. They were built for one government agency, one scientific research laboratory, and the organization that used that machine designed and wrote the software, the programs for it. And those programs had no use to anyone else who didn't have an identical computer. And there weren't very many identical computers. In fact, in the early days of computing, the fellow who was the chairman of the board of what was the predecessor organization to UNIVAC, in about 1952, estimated that someday the market for big computers like the UNIVAC might be as big as 6 or 7 of them. There might be that many needed in the whole country. Well, I think in the federal government there are now something on the order of 100,000 computers. So the market grew beyond the wildest expectations of its early some at least of the early pioneers. But things changed a lot when IBM in particular got into the market and started building a lot of relatively inexpensive computers that could be put to a wide variety of different uses. And they didn't build just one of each. They built dozens of each, and then hundreds of each, and then thousands of each. And during this time, the market for the software programs needed to make them run changed a lot too. Computers weren't just used to compute ballistic trajectories for missile ranges, and they weren't just used to compute firing tables for the Army artillery. They came to be used to do payrolls for large companies. They came to be used to do information retrieval work for educational organizations. And they attained a whole wide range of applications that no one ever thought they would do. And a lot of software was needed to do it. And no longer did you have only one computer doing one task. You had a lot of different computers doing perhaps the same tasks. Computers in dozens of companies doing payroll applications. So the economic considerations involved in software changed. It wasn't something that people, well, let me back up a little bit and say that when the computer industry was somewhere between the estimate of 9 computers and the hundreds of thousands that we have today, people who had been involved in the early days of the computer sort of regarded themselves as a fraternity or a group, a sorority of kindred souls who were used to tinkering with these cantankerous machines that might run for an hour or two between failures. And they wanted to share their experience and share what they'd done. And the practice of sharing software among similar computer installations became very common. And the computer manufacturers, in fact, encouraged it, because the more their software got around, the more tied in people would be to using their computers. So they wanted to see a lot of sharing of software. But also, about this time, some enterprising people figured that they could make money by writing computer programs separately, completely apart from the sale of computer hardware, and they could begin to sell the computer programs. And that is the beginning of what led to the decision in '64 for the office to accept programs for registration. There began to be a market for computer programs, a market where people wanted to buy these things, whatever they were, to use to run their computers. And the problem was that as soon as one of the companies really got going and began to ask its lawyers, how do we go about contracting to sell these things, the lawyers were faced with a problem because they had something that the law had never coped with before. They had this thing that some people say is a soft machine, and other people say is just a written set of instructions. And it didn't seem to fit clearly in the patent law. It didn't seem to fit clearly within the scope of copyright. People didn't know how to protect it. It didn't fall into the customary kinds of industrial or intellectual property with which attorneys in the industry were familiar with dealing. And they didn't know what to do with it. And there was a great deal of controversy and a good many articles written about how to go about protecting this. And there were people with almost a religious fervor arguing the virtues of the various systems of intellectual property protection. People who very strongly felt that the proper mode of protection for these things was patent, and that should be the only protection available. And others believing equally strongly that these things aren't machines. People sit down, they write them out on paper, they're writings of an author, and if they're to be protected at all, they should be protected by copyright. Well, the arguments weren't very conclusive, and no one school really won. There have been several cases involving computer programs which have gone to the Supreme Court without any really satisfactory resolution of the issues about the patentability of software. It looks that the court may be is afraid to have to come out and say that software is clearly within the scope of the patent laws. They also have been equally timid to say that it's without the scope of the patent laws. On the copyright side, there was agitation for the office to accept registration of programs. And indeed, the office in '64, under the rule of doubt, said that we're not sure about these things. We think that there may be some validity to the arguments that it is a machine, but on balance, we feel that there is a reasonable argument that can be made that these things are the writing of an author. And under our rule of doubt, for whatever they're worth, we'll take them for registration. Under the old law, there were problems with that. There was the thing with which I'm sure you're all familiar involving the White-Smith case, phonograph records, and the requirement for visible notation. And the question of whether or not something like these punch cards was a visible notation was up for grabs. Surely the question of whether or not the version of this thing that existed on a magnetic tape was not clear. So the office said that if this program has been, if you will submit for registration a printout of the program along with a machine-readable version of the program, we'll accept it for registration. And the office accepted, under the old law, some 2,000 computer programs for registration, approximately. About half of them came from IBM. About 500 of them came from the Burroughs Corporation, and the other 500 were scattered every place. Now, from what we learned in Cantu, that's only the tip of the iceberg, however. There are allegedly a lot of computer manufacturers who regularly put copyright notice on their software that they produce, and in fact, most of the independent software producers, the small companies that exist to write software to sell or lease or to market for use on others' computers, regularly put copyright notice on their software, but very few of them file for registration. I think one of the reasons that that's true is the point that Mary Beth brought up earlier about the potential conflict between registration and trade secrecy protection. Now, as I mentioned, there was a lot of controversy about how to go about marketing this software. Could it be sold? Should it be leased? Should it be protected by patents or copyrights? What should you do? Well, the thing that grew up as the most common means of protecting computer programs was treating the program as a trade secret, that is, something that its owner knows that gives that organization a business advantage over its competitors, and it's not known to the competitors. If you maintain such a thing, it's known as a trade secret, and you can lease it, you can license it, you can sell it. You can treat it as any other kind of intellectual property. But unlike a patent or a copyright, it's more akin to the idea of a common law copyright. It's something that is protected by the common law, and if the thing is ever published in our kind of language, if it's ever made public generally, you've lost your secret, and you have no protection against third parties. Sure. Yeah, we got, I think he was first.
Well, it's, trade secret is without specific statutory authority?
There is no federal statutory authority for trade secrecy. Many states have laws on the books about trade secrecy, establishing both civil and criminal liability
Okay.
for
Remedy is-
theft of trade secrecy or misappropriation of
remedy
trade
is usually
secrecy.
suit,
Yes,
Yeah.
an injunction.
yes.
Okay.
Doesn't the definition of publication now specifically making reference of leasing, rental? Doesn't that remove this as a possibility for continuing protection?
Well, okay, let's just go ahead and talk about it now. That has to do with the scope of the preemptive force of Section 301, and also with the scope of copyright. Section 301 preempts state laws which would grant protection equivalent to the rights granted by copyright. Well, first you have the argument as to whether or not things like computer programs are subject to copyright protection. If they're not subject to copyright protection, clearly Section 301 has no preemptive force, and you have all the remedies that you've always had available in state law. On the other hand, even if they are within the subject matter of copyright, there is the question of what are the rights provided by state law which are equivalent to the rights provided by copyright. Earlier versions of Section 301 did enumerate certain sorts of actions which would not be preempted, and it was intended, among other things, to make it clear that the state law of trade secrecy was not to be affected by the preemptive force of Section 301. Now, the question is, I think that you have to look at and consider what is the nature of a trade secret and what is the nature of the rights protected. If all that an agreement in the nature of a trade secrecy license, and trade secrets are protected by contractual arrangements between individual buyers, individual lessors and lessees, sellers and sellers, that what are the rights that are intended to be enforced by the contract? If all you attempt to do through the contract of trade secrecy is to prevent copying, that may be something that's preempted by the copyright laws. But if you intend to, through your trade secrecy arrangement, to prevent disclosure of the information, or you establish a confidential relationship between the buyer and the seller, or the lessor and the lessee, then the person having the access to the trade secret can be put under legitimate restrictions not to disclose it. And that's not a right that's protected by copyright. So it's probably not something that's preempted by Section 301. So to the extent that trade secret arrangements go beyond the kind of rights that are considered within the scope of copyright, they're probably valid. Now you can get into some very touchy arguments about what are those rights. Does that mean that if the performance right applies to computer programs, that means that I can't place any restrictions on use of the program on a seller except under color of a copyright? I don't know what the answer to that one is. Some papers we had done when we were in Cantu, one in particular on Section 301, seemed to think that the preemptive force of 301 vis-a-vis trade secrecy, and in particular the licensing of computer software, would be minimal. I'm not sure whether I agree with that, but I think it's going to be something that there'll be litigation about, and it's something that we're going to have to look out for. The manufacturers are concerned about it. Not only the computer hardware manufacturers, but the software manufacturers are concerned about the preemptive force of Section 301. And whenever the Cantu recommendations result in any legislative proposals, which we have been assured that they will, I'm sure that these points will be brought out. But I think that any attempts on their behalf to try to change the language of Section 301, I doubt if they'll be very successful.
Has the way that those enumerative sections were struck on the floor, has that created more confusion, or people just they shake it off?
I just finished reading the part of Latman's new book on copyright where he mentions that, and I think he called it a singularly confusing session. And I think that's the general attitude toward that exchange of language, which took place when those enumerative examples were deleted. I wish I could reconstruct the language for you off the top of my head, but it was something like, at the end of Section 301, it said that this is not intended to affect state rights in the nature of misappropriation, breach of confidence, and several other things. It didn't come right out and say trade secrecy, if I remember correctly. But it talked about all breach of contract, breach of confidence, the kind of things that are involved in trade secrecy agreements and other things. And the Justice Department objected strongly to that enumeration, particularly because it felt that it might codify, as it were, some federal law of misappropriation, which Justice felt would be absolutely unwise. And Justice wanted the language struck. So on the floor, Railsback said that he wanted to amend the law to drop the list of enumerative examples. And he was questioned, and the question was something like, do you intend that this will not, how did it go, change the scope of this section?
Yeah.
And he answered with some very confusing answer that was supposed to say yes, but no one is really sure whether or not it did. And it was a very confusing exchange of language. And I haven't read it for a year, I don't think. So.
I haven't either. You've probably read it more. There was a second exchange where they said, is what you're saying mean?
Right.
Yes.
And he said yes.
And he said yes.
No.
And, they
And it was
mutually
clear,
exclusive.
that's right. That
And
was the
they're
way it
mutually
was.
Exclusive. So nobody knows what it is.
He said it's not intended to change the law, and then someone asked and said, well, by that, do you mean A, B, C, D? And he said yes, and it was perfectly clear from the answer that
Like, both can't be yes.
both
Yeah.
cannot be yes,
Yeah.
because if the answer to the second question was yes, the law was changed.
But it's just regarded as being so confusing as that someone wouldn't put much weight in it.
Probably not. It's the sort of thing that a lawyer could find good arguments for either side he or she wished to argue in a case. Now, prior to the enactment of the new statute, there was a good deal of controversy regarding what was the scope of this protection that was afforded by copyright, if any. In part because of the White-Smith decision, which said that in order for something to be a copy for purposes of finding an infringement, it has to be something that's human intelligible, that's intelligible to a human being. And that created quite a few problems, and quite a few papers were written on the subject of the effect of White-Smith in the computer age. At the time of the enactment of the new law, there had been a good deal of debate in Congress about how the law should deal with computer software. Indeed, Cantu had been established as a result of those debates, and it had been assigned the task of studying computer uses of copyrighted works and to come back to the Congress with some recommendations. The new law, when it was passed, in order to preserve Cantu's freedom of action, and for other reasons, contained this section called 117 that was alluded to, which says that whatever the law is in respect to computer uses of copyrighted works as of the effective date of the new law remains the law. So in effect it preserves the law of 1909 with respect to computer uses of copyrighted works. But when you read the legislative history, it pretty clearly says that that only has to do with the rights regarding use of these works, the rights enumerated through Section 118. As to term, subject matter, copyrightability, and so forth, the remainder of the new law applies. Now, that left a very confusing situation. And as far as I know, no one has written any good article really analyzing, and Cantu, in a sense, didn't do it, interpreting the new statute as it applies to computer-related works, in the sense of what does this mean in the legislative history when it says that the remainder of the new law applies. I think one could make a very good argument that Section 117 really doesn't make any difference, because the only real issue under the old law involving the protection of copyright of computer-related works by copyright was the White-Smith case and the question of human intelligibility of copies. Well, that's taken care of in the definitions, and those are part of the law that's not subject to Section 117. Does that mean that under the new law, if you consider that White-Smith is gone and that you apply the old law regarding the creation of derivative works, the translations, other factors that might be important to people using computer-related works, that all the substantive questions are gone, and you'll get the same result whether or not if you have Section 117 or if you don't have Section 117. I don't know what the answer to that is, but I think one could make a very good argument that that's the case. Now,
I like that argument.
thank you. Now, but the question then is, why did we have Cantu, and why did it spend 3 years of effort and money to come up with a set of recommendations? Well, the answer to it is that the argument that I made is just that. It's only an argument. And people wouldn't, I could turn the argument around and say, yes, but if you continue to read Section 117, it says that it's not intended to change or affect the rights of a copyright owner in respect to computer uses in any way. So you have this tension between two parts of that section, one of which you could argue that since White-Smith is gone, the legal problems involving protection by copyright of computer-related works are gone, but then you can turn around and look at the rest of the Section 117, where it says that this is not intended to enlarge the scope of rights available, and say that, well, gee, that says that irrespective of the overruling of White-Smith, you still don't have any rights in respect to computer uses of your works.
What was the year it was?
1908.
Oh, wait, yeah.
Was the decision actually 1908 or 1909?
I thought it was 8.
It was, but the action was brought in 8. But the decision, I think the decision was in 8 also. But in any case, do you all know what the White-Smith case is? Okay, the White-Smith case involved piano rolls, and the question as to whether or not a piano roll was a copy of copyrighted sheet music. The first interaction of modern recording technology in the copyright law, and the court responded in an admirable fashion and said, no, the piano roll isn't a copy of the sheet music because I can't read it. It's not intelligible to a human being. I'm really oversimplifying things and generalizing the statement of the court. But That was the basic essence of the holding of the case. It said that in order for there to be an infringement, there must be a copy. There is no copy in this case. This piano roll with a series of holes punched in paper is not a copy of the sheet music. If it's anything, it's a component part of a machine. And it's not a copy.
But doesn't that mean that a record is not a copy?
Oh, yeah.
Those arguments were made.
That's all the old law stuff. Anybody who worked under the old law knew we would not take records as copies of the musical compositions on them.
So if I want to make a record of somebody's sheet music, I'm free to do
Oh, no.
That's why they set up the compulsory license provision.
That's, yeah.
Because of the Whitesmith case.
Now, those same arguments about the thing being a component of a machine are made about computer programs, and they're made much more vigorously because this thing probably is more like a component of a machine than the piano roll is. Now, this is maybe a good time to do this and pass this around. This is a printout of this computer program, and this thing is really two parts. There's a computer program and a database. It's a very limited database, and it's a very small program. This is the computer program. I wrote it, good lands. It's not dated anymore, but I expect I wrote it 7 or 8 years ago when I was trying to find out some information about what patents the Patent Office had issued in respect to computer programs. I had someone go over to the Patent Office and go through the shoes, the files where they keep their patents for searching, and record certain information about each patent that the Patent Office considered relevant to granting computer program patents. I had recorded certain information like the patent number, the patentee, the title of the patent, its Patent Office classification number, what technology they felt it was relevant to. And I thought it might be interesting, in the assignee of the patent, that it might be interesting to find out who secured all the patents, who held the rights to all the patents, and in what subjects did they find. So I wrote a computer program that would read this database and produce several printouts. One in patent number sequence, one in sequence by the patentee, by the assignee, one in sequence by the Patent Office's classification number, and that's all this program does. It reads these cards, it takes the data off the cards, it arranges it in a different format, it sorts it several different ways, and makes several printouts. This program is written in the language called COBOL, and it has several parts. It has an identification division, a data division, and a procedure division. The identification division is the first thing you see, and it just tells you what the program is. There's an environment division. It's been so long I've forgotten what you do. That describes the computer on which the program is supposed to run. There is a data division that tells the computer what the information it is to accept looks like in terms of format, and what the data it is supposed to print out looks like in terms of formats. It's like laying out a blank form, laying out columns on a printed form or a card. And there's the procedure division, which has kind of English-looking language that tells the thing what's to be done. To read a file, to get the input information, to sort it, to print it back out, to read it again, to sort it again, to print it out again in the different ways. And finally, to do all the housekeeping that's necessary to put the files away when it's through with it so they can be used for the next run of the program. Now, I'll pass this thing around. There's the program. There's the output from the program. Here's the cards that represent the program. The first few cards with the really crazy looking stuff at the top are cards that are needed to communicate with the computer to tell it what the nature of the program that's coming is. They're control cards that interact with the computer's supervisory program, the one that helps the computer organize itself. And then the ones that follow are the substantive cards of the computer program.
Let me ask a really dumb question. How do you get those cards?
Okay.
How are they produced?
This
Yeah.
This set of cards is the database. There are 1 or 2 cards for each patent in the file. Now, the way you get the cards is that a programmer, when writing a program, does several things. Probably the first thing that a good programmer does, if this has not been done for him or her by a systems analyst, is to draw a flow chart. Things that you've probably all seen with the boxes and diamonds and funny looking symbols that symbolically lay out the processes of what's supposed to be done in the computer. It's just an aid to help one organize one's thinking. One can write a story using flowchart symbols. Your first outline for a story. It's like an outline for an English composition. And you use this just to help yourself keep track of what's going on. And in fact, the first flowchart that you do may be very much in gross. It may have very big conceptual boxes that tell you to do a lot of things. And if some of those boxes involve very complex processes, you may write more detailed flowcharts to organize your thinking about what should be done in each of those. And eventually you get to the stage where you try to put language to the boxes. And you write a computer program. And what you do is you have a form, typically, that's laid out like many of the forms that you probably filled out, where it says write in these boxes, and it has a box for each letter. And you sit down and you write out using a pencil, usually. If you're crazy, you use a pen because you're apt to make mistakes and want to go back and change them. And you write down the language that tells the computer what you want done, the kind of statements that you see in there. You then turn that over to a key puncher, someone who sits down at a typewriter-like device and types away, and the machine produces these cards that you see, punches the holes in them and prints the equivalent codes, the letters that go with the coded holes above each hole. Now, that's really a simplification, and that's technology that's 10 years old. Typically today, the programmer, if he's good, still sits down and writes the flowcharts, but instead of sitting down then with a coding form and writing out the program, will sit down at something that looks like a Videc terminal, like one of the typing terminals that you see around the office, but it's hooked up to a computer. And that person will sit down at the terminal, perhaps him or herself, and instead of writing down the program, simply type it out on the face of the screen. And the advantage of that is it saves a lot of time. It's immediately in communication with the computer, and the computer can scan each word as its input and tell you if you made a mistake. With this one, the procedure for writing a program like this is I'd write the coding sheets, I'd give them to the key puncher would punch the cards, I'd leaf through the cards to see if I could find any just simple engross real mistakes, missing cards or things that showed up immediately. I would then take it to the computer room, I'd give it to the computer operator and say run this. And the computer operator would be able to tell me, if I asked, when the job might be back, whether I could come back later that afternoon or tomorrow morning or the next day or 2 days later, depending on the workload, to get my run. When I got it back, the computer would have told me where mistakes had been made in languages. And I could correct most of those. Eventually, when you get all the typos, kind of mistakes corrected, you can tell the computer to try to make the program work, and then you can start looking for the logic mistakes that you've made in the program, the places where the plot doesn't follow, where you don't go from A to B to C, but you go from A to B to D, and you can try to straighten those out. The advantage to the way it's done now with sitting down at the interactive computer terminal is you can do this in a matter of seconds or minutes instead of the hours or days that it took some years ago to write the programs. So that in the modern technology there may not be created a paper copy of the program for a long time. In fact, there may never be created those punch cards. There may never be created anything except a series of impulses that reside in a magnetic disc or drum And in fact, the first printout that may occur is if that organization decides to register the program and send in a copy to the office. But, pardon me,
Somebody told me that when you put it on magnetic tape and you do a printout, it comes out really in just zeros and ones and very unreadable language.
okay. When I talked to you earlier and told you about the development of computer programming languages, from when it went to the days when people sat down and wrote the zeros and ones that corresponded exactly to the language of the machine, to where we have now things that look like this, that the task of writing down the zeros and ones was assigned to the computer itself, and programs were written to translate the languages that humans can write in comfortably into the series of zeros and ones that the computer needs to operate. These things have come to have names in the computer parlance. That program is what's written in what is called source code. What the computer understands is called object code, and the object code ultimately indeed is a series of zeros and ones. Now, the mere fact that a program is on magnetic tape doesn't mean that it's going to automatically come out as a series of zeros and ones. A source code can be stored on magnetic tape, or in punch cards, or on paper, or on a magnetic disk, or in the core of a computer, and if you tell the machine to print it out, you'll get out exactly what you put in. But if the program has been transformed into this object code, and you ask to look at that, what you will get back is a series of zeros and ones. Or probably not really zeros and ones, you'll get back either what are called octal or hexadecimal numbers, numbers to base 8 or numbers to base 16.
Well, if you submit your copy in the zeros and ones, is that really something that we can accept?
Well, that's a good question, and it's a question that has been asked. I think that we prefer to have the version of the work as published. Typically, if these things are published at all, they're published in terms of the zeros and ones. But the zeros and ones are difficult to examine. They're difficult for a computer person to figure out what in the world they mean. It's possible, but instead of this program that you've had passed around is a very simple one. Anyone who knows the COBOL programming language could look at that program and in 10 minutes tell you what it does. It might not even take 10 minutes. If that program were translated into object code, even something that simple would probably take a couple of days of concerted effort by a skilled programmer to tell you what that program does in detail. Now,
Is that what they call reverse engineering? Yeah.
well, that raises another series of questions and issues.
I know you have a time thing. Why don't you tell us how long you can go, and would you be willing to come back sometime?
Sure, I'd be willing to come back. Let's say about another 5-10 minutes, huh? The question that you pose and Mary Beth's question together raise the whole question about what do proprietors want from the Copyright Office, and what do they want now in today's market for protection. I mentioned a lot of organizations market programs under trade secret arrangements, and to market them under trade secret arrangements, typically the source code, the English language looking coding that a program is originally written in, never leaves the door of the supplier's organization. The only thing that is ever put out, and typically it is not sold, but it is leased, is put out in object code, the series of ones and zeros, so that if someone attempted to print it out, there would be one devil of a job of trying to find out what that series of ones and zeros means. It could be done, but it would be very difficult, and it would require reverse engineering to figure out what the thing does. But it still could be copied and misappropriated that way. You might not know what you had, but you also might well know that if I use it on an IBM computer of this model, it'll work. And that may be all you need to know. Now, the manufacturers, suppliers, authors, writers, whatever you want to call them of these programs, have different concerns. some of them who write large and complex programs involving lots and lots of really original thought in trying to figure out how to solve the problem that the computer program solves, are interested in protecting the ideas which are embodied in the program. And they will tend to continue to want to use trade secrecy to protect the programs. They will want to try to do everything they can to make the work as hard to reverse engineer as possible. And they can do it by inserting false code in the program, things that do absolutely nothing except sit there and take up space, or they can put traps in the program that will cause the program to malfunction if certain steps aren't taken by a, quote, maintenance engineer who comes around to inspect the program every month. That if that program doesn't insert a new number in the memory of the computer somewhere, that this program can check every few seconds while it's running to say, am I on the right machine? Am I on the right machine? Am I on the right machine? By looking at this number, that it can shut itself down and refuse to work. It's done. So that if someone copies the program, obtains an unauthorized copy and attempts to use it on their machine, the machine won't have that number in it, and as soon as they try to use the program, it'll run and shut down. Some people have gone so far as to fix it so that it won't shut down in a very obvious fashion. It'll just do everything wrong. Not to any great injury to the party. That people are clever enough not to expose themselves to liability in that way, but simply to sit there and churn away and eat up 2 hours of computer time, and when it's done, write out a message that says, this is an unauthorized application of this program. No further output is made, or perhaps it's caused the program to generate 27 boxes of computer output of just pure garbage, and at the end it'll say, job aborted, unauthorized use of program, causing not any great damage, but enough to the user to discourage this attempt at piracy. Now, people who have programs of that nature also want protection against third parties. They want protection against copying. And they have a real tension. How do they get it? If they submit the program for registration, what do they submit? Will we take only the object code version? Because that's what's published. I think maybe we have to, but it's difficult to examine. But so's that source code language. As far as I know, there's not one examiner that knows computer programming. And while that program is very simple to look at and to examine, if that program were written in a language called APL, I would have no earthly idea, by looking at the code, even though I worked as a programmer for several years, what it's supposed to do. And in fact, that program that goes on for 10 or 15 pages would probably be represented in about 4 or 5 lines of APL coding. Now, it would be perfectly legitimate, and programs are still written in some of these languages that are not so human readable, called assembly languages, because they're efficient, but they are almost impossible to understand also. What if the program was written in that language originally? Would we have any choice but to accept it? I think not, even though it's difficult of examination. I think our concern with these works has to be not their intellectual content so much, but whether or not they meet de minimis standards. And I think that was the reason for asking for 25 pages at each end of the program, simply to determine whether or not there is something more than de minimis work involved in the creation of the program, something more than a trivial intellectual labor.
Yeah, I've always had some confusion over copyrightability here. Maybe because a little knowledge is a dangerous thing. I had one course in college and learned a little Fortran. I am not familiar with sophisticated programs, but the question always seemed to me, like, given this program you passed around, if people wanted to write a program in COBOL to do the same thing that you did, wouldn't they come up with the same thing? And no.
I could write that program probably still 10 different ways, easily, in a few minutes. Well, not in a few minutes. It would take me a while now, but a few years ago I could have written 10 different versions of that program in a day. Easily that many. And of course, using the idea that's in the program, you're not restricted to writing it in COBOL. If the program were written in Fortran, it would look very, very different, would be entirely different. If it were written in ALGOL, it would be still yet another sort of thing. It could be written in many different programming languages, and it can be written in each language in a different number of ways. There are theories upon which one can consider software copyrightable. One can consider it a compilation of information, and there are a lot of ways to compile and put together the information. One can consider it simply a narrative description of a process, and there are a lot of different ways to narratively describe a process. And I am running out of time, and I find that I still have not talked about everything that probably should be talked about. I haven't talked about the Cantu recommendations, and I think we need to talk a little bit more about the theory of copyrightability of these things. But I think the important things for you to know,
I know she brought Intel.
and I brought some Intel things I was going to talk about but didn't get to that, are,
Okay.
excuse me,
Well, all you have to do is tell us, go back and look at your schedule and tell us when you're available again. But we thank you very much.
maybe in about 2 weeks or so.
Now to the Iranians, right?
Now to the Iranians.
When we register a computer,
Okay.
isn't that what we left out?
That's a very good question. My first question was going to be, what would you like me to talk about today? And where did we leave off last time?
It's also less, I think you're going to talk about some of the Intel stuff too.
Yeah. Again, as with last time, if you have any questions or any things that you want me to cover, please let me know. And if a question comes up regarding what I'm talking about, don't hesitate to stop me, and we'll go ahead and discuss it at that point. If what was said here jogs my memory correctly, last time we had talked about the fact that we actually register computer programs, the fact that we've registered a fair number, the fact that this fair number that we have registered, I'm not sure that I said this, probably represents a minuscule portion of all of the computer programs that are out there in the marketplace being used by computer people, but that there are probably a substantial portion of the works that are in commerce that bear copyright notice, whether or not they're registered or not. I've been told by people who represent many firms and people from many firms that they regularly put notice on their works but don't bother to register because they don't feel it adds anything to the protection that they gain by the use of the notice. Back in the Cantu days, in this vein, many of the representatives from industry who came to Cantu and talked about the use of copyright protection on computer programs, they indicated that they really didn't think there would be much chance of a suit, from them at least, involving computer software and copyrights, because the mere assertion of their copyright in their program had been sufficient to get alleged infringers, those who had perhaps copied the program for use, to negotiate a license with them, to come to some terms over future licensing of the software. And they felt that that was providing most of the protection that they needed. Now the question that comes up is, when we register a program, what are we really registering? The law makes it clear that copyright protection doesn't extend to any idea, system, method of operation, or what have you that may be embodied in a work that's copyrighted. The question that comes up with respect to computer programs is, can you separate the work, the program, from the process, plan, idea, or what have you that it implements? And consequently, just what are we registering when we take these things? This was one of the subjects that plagued Cantu during its existence, and there were two schools of thought. The majority of the commissioners felt that clearly you could separate the process plan algorithm, to use the computer people's term, from the writing which embodies it. You could separate the idea from the writing, just as you can separate the plot of a book from the writing which gives form and flavor and life to the plot. You could separate the writing that explains the process involved in a computer program from the process itself. The minority opinion on that subject was that the two were inseparable in essence, and that a computer program was nothing more than a machine part, and hence should not be subject to copyright. I think that probably represents the way the views split up in the public at large from what I have seen. Most people are willing to accept the argument, and indeed many computer people agree that yes, there's a process involved in a computer program, but someone has to sit down and write and compose a set of instructions to give effect to that process, and that the two are separable. There are other people, many of whom tend to be involved in theoretical computer science, who say that, well, really, a computer program is an abstract machine. It is a machine in the sense that it's a mathematical, akin to a mathematical model, and you can express any machine as a mathematical model. And that, therefore, you can't separate the writing from the process that it embodies. But that tends to be a minority view, and it's not shared among computer scientists universally at all. So the question of what we're registering when we register a computer program isn't really resolved. No court has ever spoken on it, at least no court in the United States. So far as we were able to determine in Cantu, there had been two cases in the whole world decided involving copyright in computer programs, one in Finland and one in West Germany. The Finnish court held that, agreed with the minority view, if I can call it that. They said that a computer program was a mathematical process, a machine component, not subject to copyright protection, and threw the case out. The West German court, on the other hand, this was at the level of something like a state court here, it's not a reported case, held that a copyright in a computer program was valid and indeed infringed when the program was copied and sold by a competitor. So we have two cases from two other legal systems involving computer programs and copyright, one going one way, one going the other. And there's absolutely no case law in the United States so far as I've been able to find out. I had a call a few weeks ago from an attorney from a private firm with some computer clients asking if I had heard about a case that had held that computer programs were proper subject matter for copyright, but I haven't been able to turn up anything about it. If any of you in your information activities come across something like that, I'd sure like to know about it. Or if you hear get any more questions about this, I'd sure like to know where they're coming from. Perhaps we can track it down.
In most cases, when the rights of a proprietor in computer program are violated, do they seek other avenues of recourse, the trade secrets that you were discussing last time?
The most commonly used method for program protection are licenses based on trade secrecy. If you look at a book like Milgram on Trade Secrets, you'll find a large series of cases cited, a large line of cases cited dealing with computer software and trade secrecy. It's a commonly used method. There has been litigation in that area. So far as I know, none of those cases even mention the term copyright. A couple of years ago, there was a case in the Washington area involving an employee of a time-sharing company, a computer service company, who obtained a copy of a program that was being used by his company after he had left their employment. I was told by the investigators, and the case was brought to trial, the individual was prosecuted and was found guilty of an offense. The offense that he was found guilty of was fraud by wire, using the communication media to perpetuate a fraud. I was told by the FBI, one of the FBI investigators who was involved in the case, that they had considered charges of criminal copyright infringement. But because the law was so unsettled in that area, it was before the new law, that and because the penalties were rather minuscule compared to what they could get him for by the fraud by wire statute, that they simply didn't consider the criminal copyright infringement aspects.
It was fraud by wire because he obtained access to the computer because he had the time-sharing code and stole the input pulses through the wire.
Yes. A rather circumlocucious way to get at someone. That's one of the problems in protecting computer software that proprietors face. There aren't any laws on the books that deal with this new technology per se. Some states have modified some of their statutes, some of their communications statutes to take into account computer communications. There have been cases in California where the same sort of thing has happened. It's been attempted to prosecute the people for theft of a trade secret. And some of the cases have not been successful because nothing was taken. If the only thing that was done was copying electronic impulses over a wire without ever making a permanent copy or a printout of it, there hadn't been any theft of the trade secret. Nothing physical had been picked up and carried away. In those cases, had the individual gone to the firm from which he was alleged to have taken something and carried away a printout listing the program like the one I showed you the last time I was here, he might well have been found guilty of theft of a trade secret. But because it was done electronically by wire and nothing physical was carried away, some of the prosecutions haven't been successful. It's a complex area, and it involves more than just copyright. But the thinking, at least of Cantu, was that copyright in a limited area could go a long way to solving some of these problems because it would provide uniformity, which doesn't exist now, and that copyright is, of course, a federal body of law, and that at least you would have, if the recommendations suggested by Cantu, which I think I reviewed last time, were adopted, at least there'd be one body of federal uniform law that dealt with certain aspects of the protection of computer software and databases and other works which might be used in computer systems. Are there any other questions about the computer program business?
Yeah, how do you feel about computer codes, about the combinations of numbers needed to access a program? This guy came in as a walk-in. He had a sheet with a list of cities down one side and a whole combination of numbers that were used online to access that central base from each city. You had to find what city you were accessing from and then read across and get your number code.
Mm-hmm.
And he wanted to register that as a computer code, which was used to access a central program. And the examiner at the time determined it was a blank form. We weren't going to register.
To me, it seems more like that would be a telephone directory. It's a set of identifiers and addresses that go with the identifiers, like a telephone
I
directory.
don't mean to be so specific. I meant to be more, obviously, in order to get into a base. I mean, we have it here with
Sure, you
the
have to have an
online system
access
here.
code.
You've got to have a code. How do you feel about registering the code?
If you have a tabular listing of the codes, it's like any other table of information. If there's sufficient, quote, authorship involved in compiling the table, setting up the correlation of number to identifier, why not register it?
Okay.
To what does the protection extend is the question.
Yeah.
And that's not entirely clear when you have a listing of tabular data. Generally, because it's factual information, the protection is thought to be fairly thin. But there's a case called Roxbury Data versus the New York Times, in which manually an organization prepared an index to the New York Times index. You familiar with the New York Times index? Everybody familiar with that? It lists names, identifiers, and gives you the page in the New York Times, an issue, and so forth, where you can find that information. An organization prepared a set of, and these things are published annually, I think, or biannually, whatever. But anyway, there's a big bunch of them. And if you want to find all the information about Barbara Ringer, you'd have to go back to 1949 or so and look forward from that date, looking at every year to find out wherever her name was mentioned and to find out every mention of her in the New York Times that way. It would refer you back to the original work. Well, this group prepared an index to the set of indexes so that you could go in their index to Barbara Ringer, and it would tell you that her name appeared in index volume 23, 27, 31, 42, and so forth, and it would give you the page at which it appeared in the index. The New York Times people sued the Roxbury Data people, claiming that this was an infringement of their copyright. Well, the court found that it wasn't an infringement, and in doing so, it made some interesting discussion about what was the smallest protectable element involved in the New York Times indexes. And it said that the correlation of an individual name with the page reference at which it appeared was something that was protected by copyright. It was the smallest copyrightable element involved in the directory. And since the people who compiled the index didn't take that, they only took the name, and then they added to it the volume and page in the index in which it appeared. They hadn't taken something from the underlying work that was copyrightable. But it's interesting in the context of the directory that you brought up. What is the smallest protectable element? I don't know.
I had one. Are you familiar with the cassettes? They have little beeps that trigger computer programs. You get them and examine them, they look like phono records, but they're really not. And they really are part of the computer program.
Part of a computer program.
Yeah.
Well, a lot of computer programs for these small computers, like the things that are sold at the Radio Shack, use programs that are stored on things that look exactly like audio cassettes, little Philips-type cassettes. And they are software products. They are programs. I'm not...
Okay, my question was, in those kinds of things, since that's the way they are sold, a little cassette kind of thing, in our deposit regulations, we would not take those? Well, do you know what we do?
We'd require
The visibly noted?
the visible notation.
I would guess.
Yeah, I would think. The first and last 25 pages, which we may end up modifying at some time because it may be too much, especially in the case of these little
These
programs.
little things,
Yeah.
yes. Well, in that case, it's the first or last unless it's less, right? Which case
Right.
it's the whole thing.
Yes.
Yeah.
That brings up another question that I don't remember whether I discussed last time, and you may get questions about it. And that's the question of secure deposits for these works.
Before you do that, can I ask one other question?
Sure.
If you get that in, would you, people shouldn't be suggesting that that's a PA or an audiovisual or a sound
No, no.
recording. It should be what, TX?
Should be a
That's what I said.
TX.
What would the visual notation be? Because I've had people come in or call on the phone too, and they say that they're just audio. That's it. It's just sounds, and the sounds
Yeah,
trigger
beep.
certain responses in the machine, and they regard those as programs.
Yeah.
That's a good question. I don't know.
Sheet music.
I
don't
don't
think
know.
so.
Because it's not equipped ever to print out. It's not equipped ever to.
Right, that's what was
I'd
troubling me.
like to find out something more about that. Do you? about the technology that's involved. I don't either.
It seems,
No.
it seems like a mechanical device. They have a pattern of sounds, and which when the machine hears the sounds, the machine responds in a certain way.
But when they would have had to start with the program and put them into the sounds, wouldn't they? I mean, somewhere there's got to be something.
Somewhere there has to be something involved, but I'm not familiar enough with the technology to know.
It's becoming more and more of a question.
I know that there are computer programs that will make a small computer play music, where you have the reverse situation. You have a set of instructions, and what comes out the other end of a speaker hooked up to the computer is something that simulates music. But in that case, what you have to start with is a computer program. What you're talking about is something that's sort of the reverse of that. You have a set of tones or sounds that activate the machine and cause it to do something else.
Right.
That's right.
That's a good question. I don't know about those.
So next time we get a question about them, transfer the call.
Yeah. Transfer the call to me. I'd like to find out something about it. If you get one that sounds intelligent,
Yeah,
that they
right.
know what they're talking about.
The problem is when you're saying, well, what does it do? And they go, ah.
Yes, if you get one who's able to explain it, I'd sure like to talk to them.
It isn't just,
I'll do a little investigation on my own, too.
it isn't just fly-by-night people, because I remember I had a couple of calls
Oh,
from
no.
Burroughs and.
Well, we've got
Oh,
some
no.
in upstairs.
Oh, yeah.
I don't know what they've done with them.
Well, they didn't know what to do with them. That's part of the problem. And some people didn't recognize that they weren't sound recordings, and they took them in on SRs.
Well, they may be sound recordings. I don't know what they are in
I
this
don't
case.
know what they are either. But if you listen to them, all they do is go beep, beep. Some of them, you know, they have these funny beeps.
It's like the
They're
phone.
weird.
You couldn't, it couldn't be a PA. Remember we had that
Yeah,
one
I think
downstairs
I don't know
and
what
they
they
had
are.
a drawing to show
Yes,
how
exactly.
what the machines did when it heard the beeps.
Right. Didn't he have it set up to run on audio as a component of an audio-visual work? The
Yeah, it
slides
was
were
it
going
was
to
a
change.
slideshow and it
It's the
little
keying
beeps.
instructions.
Yeah, told
Yeah.
the machines what
It's like a
slides when the
sub-program.
Well, they're a little bit. Some of those are different. I've seen those where there's a cassette and it's got two sides. One is the kind of thing where you can completely control it. The other one where on certain beeps it will move forward and it will. You don't have to worry about the slides. It will do its own thing. But these are.
I would argue that something like the keying thing for the slides is just a mechanical component of the device. And I think that I'd be willing to try to extend that argument to sounds that just cause the computer to do things. I think.
I think so too, but I think there is something
But-
copyrightable somewhere. I don't know what it is.
The
and it's almost-
arrangement of
right.
those sounds could be copyrightable.
That's perhaps true.
Oh, it's so minimal.
That's perhaps true. I don't know how they're generated. I don't know
I
what
don't
they
either.
do. I don't know how you get there, and I'd like to know more about that before I really decide. But
Yeah.
it seems to me that in this whole area, when you're talking about any kind of compilation of fact type work, which is maybe what a computer program is akin to, we tread, I think, fairly close to the dividing line between what's copyrightable subject matter and what belongs somewhere else in the law, perhaps in patent. And I think in some instances a case may fall on one side of the line or the other. Maybe this case with the sounds is one that falls on the other side of the line, but they're close. I'm not sure yet. I'd have to look at that one. I'll have to find out some more about it. But you say you've had calls from people like Burroughs about this?
Yeah. This was a couple of months ago. This was maybe, I remember about 5-6 months ago it started. And then there were, in 1 week, I remember that's why I noticed it, that there were.
Were there any other particular ones that you recall, any other companies?
I saw something, again, I don't even remember where it was, but I saw something in print also, an article. Somebody wrote us a letter and asked us information about it and enclosed an article. So
Have the things that have come in been on SRs? Because I can check with Mildred.
I was just going to say, it seems to me that the bulk of these things end up in the performing arts section. And I think they do come in on SRs.
Okay.
And I know, in fact, that she didn't know what to do with the deposit, and she was hung up with what to do with them. And she asked for some advice, and she never got it, so she just made some decisions on her own, and I don't know what they
Okay.
are.
Thank you for the info.
Let us know what you find out.
It would bug
I
me.
will. as long as we're talking about things that fall right on the borderline between things that probably are protectable by copyright and things which probably aren't, it's a good time to talk about the business involving microcircuit chips, because I think there is a case that lies right square on the borderline. I'm not sure whether it lies on the borderline between what's constitutionally copyrightable and not, or what's statutorily copyrightable and not. And there are two questions involved. If you've ever looked at the inside of a calculator, you've seen little wafers, maybe 3/4 of an inch, an inch and a half long, with a whole bunch of pins that come out of the sides, to which are either plugged into a printed circuit board or have a lot of wires going away from these pins to other things. Those little wafers contain very complex electronic circuitry that's capable of doing a lot of things. Today, for $100 or $200, you can buy a small calculator that incorporates one of these chips that has as much computing power as the UNIVAC 1, the first commercial large-scale computer that was ever manufactured. That would have filled the whole first floor of this building, that would have required a separate refrigeration plant to keep it cool, and which maybe could run a half an hour between failures before a vacuum tube blew somewhere and caused the whole system to come crashing down. These little chips don't require any refrigeration. They cost $20, $30 a piece, sometimes even less, sometimes more for specialized ones. And they can do the same computational job that that whole monstrous computer could do a few years ago. A few years ago, 2 or 3 years ago, at a computer conference, the National Computer Conference, which is the big annual conference for computer people, the president of Texas Instruments gave a talk, and to emphasize his talk, he reached into his pocket, pulled out a handful of these things, threw them out to his audience, and said, now, if this had been 10 years ago, I'd have just given away half the money in the country, and went on to relate the cost of something like a UNIVAC 1 in millions and millions of dollars to the $5 a piece or $10 a piece for the little computer chips that he threw out to the audience. Literally gave away more computing power in those few seconds than had existed in the United States 10 years ago. A very dramatic experience. These little chips are made by an interesting sort of process. They are transistorized devices, and if I use some of the incorrect, not the most accurate terminology, excuse me.
We won't know.
But they are transistor-like devices, and they're built up on little tiny chips of silicon. The process starts off to make these things by making very, very high purity silicon rods about the diameter of the top of the coffee cup. These things are made with a purity that goes down to parts of impurities per million or billion parts of silicon dioxide. And these rods are made, maybe this long, and they're expensive to make too, but that's not part of the copyright concern. After the rods are made, they're sliced up into tiny wafers or discs, thicker than a piece of paper, but maybe the thickness of a 3x5 card, the thickness of a punch card, something like that. And onto these wafers are imprinted, by a process akin to photography, diagrams of circuits. And in fact, the diagrams of the circuits become the circuits themselves when these devices are properly treated with chemicals and heat and ultimately connected together with another thin layer that's chemically, or that's more or less photographically deposited, of thin metal. Well, how do they do this? There are very highly skilled people in that industry who take an electronic circuit, laid out in conventional circuit notation like any electronic engineer's circuit diagrams, with all the squiggles indicating resistors and all the other symbols that are used indicating transistors and capacitors and so forth, and translate that into a drawing that's the size of one of these tables. And it lays out what the patterns are going to look like on this chip. And there are patterns that correspond to a transistor, to a specific kind of transistor, to a resistor, to a capacitor. And for each one of these things that ends up being incorporated in the circuit, there are lots of different ways to do a capacitor. There are lots of different ways to do a resistor. And there are lots of different ways to hook them up together to make the same electronic circuit. So that what you end up with in the drawing isn't merely a larger scale version of the engineer's circuit diagram, but it's a very carefully constructed drawing that lays out the topography, the surface pattern of what this chip is going to look like. After the drawing is prepared by a human being or a team of human beings, it's very carefully checked over by engineers to make sure it's accurate. And this whole process costs a lot of money. Many person-years are involved in creating one of these drawings. If it's a complex circuit. If it's a very simple circuit, of course, less time is involved, but they're very expensive to make even up to this stage. After the drawing is initially prepared, it's taken to something called a flatbed plotter, which is like a great big drafting table. It's taped down to the drafting table, and there are a set of arms on the drafting table, like a pantograph, that has on it a little round gadget with a stylus under it and some buttons on it. And this is hooked up to a computer. The drawing has been prepared in multiple colors by the designer, where each color indicates what's going to be ultimately a layer in this chip. When the thing is taped up to the flatbed plotter, pardon me, I've used the wrong name. That's not a flatbed plotter, that's a digitizer. That's a digitizer. When it's taped up to this thing, another skilled technician takes this box with the stylus on it that's mounted to arms and moves it to the end of a line, punches a code into it that indicates that this is the end of a red line. The machine, because it's hooked up to the arms on which this little box moves, knows where the relative position of that is on its table. The technician then goes to the other end of that line and punches in another code to say that's the end of a blue line. The machine records the position. The machine now knows that there should be a line on the blue surface, which maybe is the first one, that goes from this coordinate to this coordinate. And that process is repeated for every colored line on the drawing. And you end up with a computer tape. After that's done, the computer tape is taken then to a flatbed plotter, which is another big drawing device that reverses the process that it just went through. It has a set of arms with a head on it with multiple styluses, styli, with different colored pins, such that the computer then will reproduce the drawing that you started out with. And the engineers take this and they check it against the original drawing to make sure it was digitized accurately. After that's done, the tape is taken to another computer, it's fed through that computer, and it comes out, it in effect separates each layer. It makes a drawing for the blue layer, a drawing for the yellow layer, a drawing for the red layer. And in some of these chips there may be as many as 7 or 8 of these layers, some only 2 or 3. Those drawings are reproduced on the plotter and they're checked again to make sure they're accurate. When everyone is satisfied that the drawings are accurate and that what's on the computer tapes actually are the coordinates of all the lines that are needed to make up one of these complex drawings, That's taken to a computer-controlled camera. And the computer-controlled camera reproduces an equivalent picture of each layer in a size something around 1 or 2 centimeters by 1 or 2 centimeters. You know, something half by 3/4 of an inch or 3/4 of an inch by 3/4 of an inch, depending on what you're going to end up with. And each one of these tiny little drawings contains all the lines that the big drawing of the layer which it corresponds to contained. There may be 7 or 8 of these involved for an individual chip. These drawings, these photographs, are then taken to another machine that reproduces hundreds of them on a round disk that's going to be approximately the same size as the silicone wafers that I talked about earlier. And it just reproduces them in bands across the chip, divided up. So there are just hundreds of them on the surface of one of these reticles, they're called. These reticles are then used as the negatives in the photographic process to impose on the silicon discs that I talked about the images of each of these circuit layers. Now, part of the process in checking the accuracy of these things is to take this size picture that I talked about before and produce a blow-up of the negative, a Mylar sheet, the so-called Mylar sheets that you may have heard about us accepting for registration as a scientific drawing. The ultimate result of this process, and this photographic process using this reticle, is a silicon disc with a whole bunch of different layers imposed on it. A different reticle is used to correspond to each layer of the chip, and you end up then with a silicon disc with all of these little images on it. The thing's taken to a scribing machine that scribes the lines between each one of these. They're broken apart, and they're assembled inside little plastic packages with wires hooked up to them. And then they're used for a lot of different purposes. Some of the things, as I mentioned, are small computers that have the power of big computers of a few years ago. Some of them are storage devices that can store data, information, just as data or information is stored on a magnetic tape or on a phonograph record or what have you. Some of them are just memory devices. Some of them are combinations of the two, computer and memory. Some of them are empty when they're manufactured. Some of them, when they're manufactured, contain computer programs. Some of them, because of the way they're constructed, can never be, the data in them can never be changed. It'll always be there. It's part of the way they were manufactured. Others of them, like a piece of magnetic tape, can have data imposed on it, can have the data erased, and can have more data imposed on it over and over. They can be reused. So they have a lot of different capabilities. One of the things that at least one firm incorporates in each of those circuit masks is a little circle C and the date and its corporation name. And it also, when it makes the chip, ultimately, puts a notice on the chip. And they've sought to register various combinations of the things that I've talked about here.
Despite all the variations of what may be stored on there, is it completely inaccurate to think of them as compilations of pre-existing information?
Not necessarily. It's not necessarily inaccurate to think of them that way.
When you were talking about
They could be.
layering drawings and what the styli creating a layering effect on the chip of drawings that already exist. It seems as if we're creating a compilation of pre-existing material.
Well, one of the arguments that the people who want to register the chips make is that indeed that's all they are. They're a compilation of works. As such, there's copyright in each layer, there's a copyright in the compilation. But this raises some problems. It raises basic copyright problems. If it's clear that we'll take a scientific drawing for registration, so long as it contains sufficient authorship to be a copyrightable work. Now, one class of scientific drawings that we'll take are blueprints. Now, the protection that's accorded to architects' plans or blueprints is kind of funny. It extends to the blueprint, but not to the structure that's built from the blueprint. That is, if I have a copyright in a blueprint to build the Brooklyn Bridge, and someone looks at my blueprint and builds the Brooklyn Bridge from the blueprint, they have not infringed my copyright. However, if they copy the blueprints, they've infringed. Now the question is, which is this chip? Is the chip the Brooklyn Bridge, or is it a copy of the blueprint? Is it the utilitarian device that results from working from a plan, or is it merely a copy? The proponents of copyright in these chips say that, gee, what's different from this than making a Xerox or a photographic copy of something? That's all I've done. I've used a process analogous to photography to copy drawings. Why shouldn't copyright protection extend to the chip? You turn around and you make the other argument. It's not a copyright to make a utilitarian object from a written or a drawn description of that object. It's not an infringement to build a car from a copyrighted set of plans for a car. It's not an infringement to build a computer from a set of copyrighted plans, blueprints, circuit diagrams for that computer. Probably not, at least it isn't. So where does this thing fit? Is it building something from plans, or is it copying a drawing? No court's spoken on the subject. Congress hasn't spoken, and the opinion of the industry is divided. A group of these companies who operate in an area called Silicon Valley, south of San Francisco, because that's called Silicon Valley because of just every other building you see driving down the highway south of San Francisco, is a microcircuit chip manufacturing company. A group of those companies got together and got a representative from their area to introduce a piece of legislation that would say, I think Mary Beth has it.
Yeah.
Go ahead and read it if you want.
Oh, it merely says that they want to amend the Copyright Act to provide protection for imprinted design patterns on semiconductor chips, and how it does it is by putting or amending the definition of pictorial, graphic, and sculptural works to add that these works shall also include photographic masks used to imprint patterns on integrated circuit chips, and include the imprinted patterns themselves, even though they are used in connection with the manufacture of or incorporation in a useful article. That's all it says.
Yeah. That's all it says, and that's what they want the law change to state. They feel that that would provide them the kind of protection that they say they need. And the reason they say they need the protection is it's possible to take one of these chips and chemically disassemble it. In effect, peel off layer by layer, and using microphotography, reproduce the masks from which the chip was made, clean up those masks a little bit by retouching to get rid of any rough lines that show up because of blow up and photo reduction processes, and go into competition making competing chips exactly like the ones that the original manufacturer started out with for a small fraction of the investment that the original manufacturer had to incur to make the chips. And they claim that they need protection. They claim that providing a copyright-like protection would not impede the growth of the technology because they argue that there are dozens, hundreds of different ways to implement any particular circuit in a chip. That if you have an engineer's circuit diagram, you can make a dozen or 100 different chips that equally efficiently implement that circuit. So they say that you're not providing protection for the electronic circuitry through copyright. But that's not entirely clear. That same argument has shown up in respect to computer programs. I think maybe I went over it last time, and that's that because there are a lot of different ways to write a computer program, given the process upon which it's based, there's no reason not to apply copyright. And the analogous argument is made about these chips. Well, there were hearings conducted on this bill at which John Baumgarten testified. And the sponsors of the bill thought it was going to sail through without any opposition. But it turned out that people from the industry, some people from the industry opposed the introduction of the bill, opposed its passage. It's not clear exactly why they opposed it, whether they were people who engaged in this chemical disassembly, which some people prefer to refer to as reverse engineering and other people call copying. Which it is, I don't know. The people in the industry don't agree on which it is to chemically disassemble the chip. Some say all they're doing is extracting the idea that's involved in the chip and reusing it. If that's all they're doing, that's not a copyright infringement. It's not a copyright infringement to use the idea that's embodied in a copyrighted work. But if you copy the form of expression, it is an infringement. Now, what is this act of chemically disassembling the chip? I don't know. I don't think the people who introduced the bill know. And this was the position that the office took on the bill, is that there are too many unanswered questions about this. It's not clear. We think, the office stated that we think probably Congress could pass legislation like this that would make these chips and the patterns imprinted on them subject to protection by copyright. There probably is no constitutional impediment, I think we did go that far, to considering these things protected by copyright. But right now, they're outside the statutory limit of protection. That the relationship between patent law and copyright law in this area is not clear. It should be explored. If there is to be a design bill introduced, perhaps that might be the right way to protect these things. And is the term of 75 years or 100 years or life plus 50 years needed for these technological devices, which probably are obsolete 5 years after they're made, maybe 10 years? We raised these questions and suggested that there be a little more study in the Congress on them, and I think that that was generally agreed upon. So there's likely not to be any action on the bill. But in the meantime, we're faced with the problem of what do we do about these chips and the masks that are used to produce them. Well, the position that we've taken thus far is that we will accept for registration the Mylar sheets that represent each of these layers. We'll take them as scientific drawings. We will not accept a chip for registration, but we'll take the sheets. They're scientific drawings. How can we refuse not to? We could, but it might be inconsistent. So I think that under our rule of doubt, we should take the drawings, and we do. But that's as far as we'll go at this time until Congress tells us differently, or a court tells us differently. That is probably the most controversial computer-related subject that I'm aware of right now that affects copyright. Is how will this question be resolved? Who's going to come out on top? Will these things be protected by copyright, or will they be decided to be outside the scope? I don't know. I don't know how it's going to go. But it is an active question. The other possibilities that may come up have to do with what's going to happen with the recommendations that Cantu made. Likely there will ultimately be some hearings on getting rid of Section 117 of the new copyright law, which was Cantu's basic recommendation, so as the new copyright law would apply to computer uses of copyrighted works without question. And the other smaller recommendations that Cantu made for sort of perfecting changes in the law. There were no sweeping changes recommended in respect to computer uses. But I think the changes that were recommended are basically sound and were based on a good study of the area. And I think they're generally fairly well supported by people in the industry. So we may see something in this Congress to implement the Cantu recommendations. I don't see, other than this one that you just mentioned about the, what in the world to call these things, the sound actuation tapes, I don't know of any other computer-related issues that are likely to be bothering us for the immediate future. The thing that a lot of speculation has been done about is what about machine intelligence and the creation of copyrightable works by computers. I think everyone who's looked at that problem in detail, other than thinking about it for a few moments and saying, gee, there are a lot of problems, have come to the conclusion that there really aren't any problems there. That a computer doesn't create anything, and it's not likely that a computer ever will create anything in the sense that a human being creates something. That's not to say that works that are produced by use of a computer are not copyrightable. They are, to the same extent that works that are produced by using a camera or a typewriter or a quill pen are copyrightable. If there's authorship, the work's copyrightable. If the person who created the work exercised some discretion in choosing what computer program to use, what input data to give it, how to select from among the things that it did, those which were found to be a pleasing design or whatever, persons exercised copyrightable authorship and the work that's produced is copyrightable. If the work that comes out was simply the result of a mechanically preordained process, there's no authorship and it's not copyrightable. That was the suggestion that Cantu had to make in the area, and I think from the other studies that I've ever seen, one in Japan, I think, is the only one that's really touched on it, reached exactly the same conclusion. I don't have anything else to say.
I have one thing. I took you off the track at one point by going with my tapes with the beeps on them. You were going to talk about the area of security and I think
Secure deposits.
the secure deposit kind of a thing and the special relief. I was wondering, I know that a lot of people had made the request for special relief that they wanted to give us less than our deposit requirements required, and they were being gathered in the examining division. Has anything happened? Have we developed any standards? Where are we?
Where are we? As far as I know, where we are is that we know we have to do something, and we haven't done anything yet. Because I think in part it's part of the whole question about what do we do about special relief for this whole category of works that embody trade secrets. Whether or not it's a manual, or whether or not it's a LSAT, law school admission test and the answer sheets, whether or not it's a computer program or what have you. How we treat these secure deposits is right now an open question in some areas. We have set forth procedures for dealing with secure tests, but how this applies to other works which embody trade secrets is an open question. I think that's one of the things that you may get queries about, and I think that in that case the only thing you can do is refer the people to the General Counsel's office or to the examining division, and we'll just have to take their information and conduct a hearing on the subject, I think, ultimately.
So what do you think we're going to do? I knew almost it's neat. We all go out and we say, oh, there's special relief and you can ask for it. But it seems like we haven't done anything when they ask for it.
I'm not sure how much has been done, whether or not special relief has been granted in particular cases. I don't know how many cases in which special relief has been requested involve computer programs. I think that's some information we have to gather. But if there's as many as the questions that I get when I give talks indicate there should be, it's going to be a problem we are going to have to do something about.
Yeah, I thought so too.
The
And
qu-
it was bothering me to go out and say this when it looks like maybe we're gonna renege or maybe we're not gonna do it.
I think we'll have to do something ultimately.
If a person was going to take the position that a chip was copyrightable and wanted to put the notice on the chip, how do they do it?
Well, the thing that ultimately comes out looks like a little wafer of plastic, maybe this long and this high or smaller. The way the manufacturers that do this now do it is they put a Circle C, the year, and their company name on it.
Yeah, so it's visible.
It's visible on the surface of the chip.
What if it's so small you can't get it on there?
They're not that small. They have the chip itself. There isn't, as I indicated, when they make these drawings that ultimately end up being photo reduced till they're just tiny things, a few millimeters by a few millimeters, there may be a microscopic copyright notice on each layer that ends up being reproduced inside the chip, but it's not visible.
Well, that wouldn't be acceptable, would it? It's not visible to the public.
That's right. So that's why these companies put the notice on the surface of the chip. The technology that exists right now is such that the chips have to be packaged inside a, quote, container. And the position these companies take is they'll put the notice on the container in which the work is packaged.
Wasn't there one time an argument made that the type? Well, when the chips are made, they're sort of pressed and they have a typography. Didn't they once argue that the typography was the sculptural aspects were copyrightable, and they were going to try it that way?
Yes,
Mhm.
that's
What
been
happened-
argued.
What happened to that?
Nothing.
Did we just ignore that argument, or tell them that they
No,
were
no.
crazy? Or?
No. We've said this is one of the things that needs to be explored. What is the nature of the thing? Does it exist as a flat surface when you get through with it, or is there really a surface topography?
Well, what is there really a?
I don't know. I think in some cases there are, for certain kinds of circuits and certain kinds of chips, the things do end up with a surface topography, and in others they don't. They end up with a set of impurities that are chemically diffused into the chip, and you end up with essentially a smooth surface, I think, but I'm not entirely sure. And I think it may depend in part on the manufacturing process that's used.
We should all go to California and have a tour of one of these places.
I've had a tour of one of the places.
Oh.
Well, at one point we were gonna have a hearing, but I think we've discontinued our idea of that because of the
Well,
pending
until we find out what's happening with the pending legislation.
Right.
Because
And
we
if we had
have
a
to
hearing, we
decide.
would have learned a lot in some of these things. Because we could have asked our questions about deposit registry. Well, I think even if this legislation passes, we'll have something on,
If the legislation passes, we'll have to have a hearing to find out how we implement it.
yeah,
If the legislation doesn't pass, we probably should hold a hearing too to find out what in the world we're doing.
right.
The language in that legislation is rather specifically drawn.
Oh, yeah.
And
Yes.
you can't be sure that having gone through all that, it would not be then made obsolete by new technology.
That's right. And that's the argument that
I-
some companies have made.
Yeah, I'm not sure that by addressing it piecemeal, which in effect you're doing here with current technology, that maybe the philosophical approach would be better.
Well,
But I sure wouldn't know how to do that.
that's what hearings are for. But, congressional hearings at least. But the technology in this area is changing fast. Some of the very high technology companies like Bell Laboratories, high technology research areas, claim that it's possible to completely bypass this whole photographic process in the manufacture of chips now and to do it totally electronically without ever coming to a mask. It's possible to write a computer program and convert the computer program directly into a chip without going through these intermediate stages of masks using electron beam technology. Now, don't ask me to explain it because I don't know really what it is, exactly how it works, but I have been told that it's possible to completely bypass the photographic mask stage. It's not commercially viable now, and some people think it will never be commercially viable, that this photographic technology will always be cheap enough that it will never pay to bypass it through the totally electronic means. Others believe that the totally electronic means will ultimately replace this technology. I don't think it's soon enough yet to know how that will develop.
So the question is getting complicated further by eliminating any fixations
Yes.
that may exist along the way. You're suggesting they come to the point where the chip comes out at the end, and you may
That's the only
hard-pressed to find
fixation.
any fixation
Yes.
prior to that.
Now, if I can be excused, I think I'm going to have to go.
Yeah.
Thanks a lot.
Thank you for having me. I enjoyed it very much.